Members of the committee, today's hearing provides an important opportunity to examine whether the Ninth Circuit Court of Appeals is able to adequately perform its duties as it is currently structured. The hearing takes on an added importance in the wake of a series of decisions in the Ninth Circuit and elsewhere overturning President Trump's Muslim refugee ban. Instead of coming to terms with the legal flaws with his own executive order, President Trump has chosen to attack the Ninth Circuit, which he has said is in chaos and, frankly, in turmoil. Those are quotes. Last night, after learning of the Hawaii court's decision again rejecting his ban, he said people are screaming to break up the Ninth Circuit. You have to see how many times they've been overturned with their terrible decisions, in quotation. Of course, none of what the president has charged about the Ninth Circuit is true. The Ninth Circuit is well organized as any in the country. Of the very few Ninth Circuit cases the Supreme Court takes up, a significant are overturned. But that's true for every circuit, several of which are overturned at a higher rate than the Ninth Circuit. And overall, less than 0.1% of the Ninth Circuit decisions are overturned by the Supreme Court. The reality is, this is not a new debate President Trump has brought us to. It is one that we have had for decades. Although I will not speculate why there continues to be such an interest by some of my conservative colleagues to divide the Ninth Circuit, there are several points we should keep in mind. To begin with, splitting the Ninth Circuit would not bring justice closer to the people. Instead, it would likely result in further delay, reduced access to justice, and wasted taxpayer dollars. If the Ninth Circuit were divided, there would not be sufficient judicial resources, particularly with respect to addressing the significant caseload demands of the district and bankruptcy courts. Although legislative proposals introduced this Congress take differing approaches to dividing the Ninth Circuit and creating a new 12th Circuit, inevitably all of these have one common problem. Such restructuring would result in a significant financial cost to American taxpayers because millions of dollars would be needed to construct a new circuit headquarters and for costs. Another concern I have is that splitting the Ninth Circuit would do little to improve judicial efficiency, and none of the legislative proposals would actually resolve the heavy caseload problem because a clear majority of the Ninth Circuit cases come from California. Any circuit that includes all of California will still have the largest number of judges and appeals, and it would serve the largest population. Finally, I am particularly skeptical of any legislative proposal ostensibly intended to assist certain entities when, in fact, those very same entities oppose or question the need for such a legislative fix. Dividing the Ninth Circuit is opposed by a majority of the judges in that circuit, as well as by the bar, including the American Bar Association itself. In fact, the White Commission, which Congress established to study the issue, concluded in 1998 that splitting the circuit was impractical and unnecessary. And so I ask my colleagues to very carefully listen to the witnesses today and join me in opposition to dividing the Ninth Circuit. I thank you, Mr. Chairman.
And I thank you.